Good afternoon, and thank you for joining us for an MP webinar covering hiring and firing in 2022, best practices to reduce legal risk. I'm Katie Kreiter, Marketing Specialist here at MP. For those of you joining us on a webinar for the first time, MP is a full-service human capital management company. We offer a complete suite of products and services to support organizations through the entire employee lifecycle, including HR, payroll, benefits administration, time and attendance, and compliance assistance. We support our clients with cutting-edge technical solutions, as well as proactive, reliable service and deep HR and payroll expertise. At MP, we are wired for HR and help our clients succeed by aligning their people strategy with their business goals. I'm excited to introduce your presenter for today's program, Stefani Schwartz. Stefani has devoted her legal career to representing employers in all aspects of employment law, including discrimination, harassment, retaliation, and wrongful termination matters. Stefani dedicates herself to counseling her clients and ensuring that proper and effective employment policies are in place, as well as assisting in the hiring, firing, and disciplining of employees. Stefani's expertise is also called upon to conduct internal investigations in a timely and efficient manner. Stefani has represented hundreds of clients in state and federal court proceedings and before administration agencies such as the Equal Employment Opportunity Commission, EEOC, and the New Jersey Division on Civil Rights, DCR. She has several reported cases and has been successful with jury and non-jury trials. From 2012 to the present, Stefani has been named to the New Jersey Super Lawyers list in the area of labor and employment law. Furthermore, in 2015, she was named to the New Jersey Top 50 Women Lawyers by the Super Lawyers publication. Stefani is an active member of the legal and non-legal community, serving on many boards and committees for nonprofit organizations, banks, and professional associations. Hatfield Schwartz Law Group is a woman-owned law firm located in northern New Jersey, with a practice centered labor and employment law. Founded by Stefani C. Schwartz and Catherine V. Hatfield in 2020, the firm provides dedicated personal attention to each of their valued clients. Hatfield Schwartz was created with the mission to focus on client issues and determine innovative solutions with an unparalleled level of quality. Proactive business solutions, assisting their clients with all their legal needs. For more information, including how to contact, please visit www.hatfieldschwartzlaw.com. And just a few housekeeping issues before we get started here today. If you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen. And as a legal disclaimer, this training is intended for educational and informational purposes. While we hope you learn a lot today, the information should be constructed as legal advice. We will be sending out the recording of the webinar later today, along with the slides. And with that, I'm going to hand the mic off to Stefani.
Thank you very much. I wish I could see everyone because I would ask the following questions. How many people in the audience have received an internal complaint where they work? Lots of you are raising your hands, if not all of you. And then I'm going to ask a second question. How many of you have received a formal complaint, whether it be a lawsuit or an administrative complaint? Guarantee almost all of you are raising your hands. And then I'll ask another question. How many of you have received that letter from plaintiff's lawyer? And I know I'm a little bit of tongue in cheek, but I call it the extortion letter, the letter that demands an exorbitant amount of money because, of course, the company failed to do something in their eyes or discriminated against someone or harassed someone. So for the most part, if you have one employee, one of those three items you will see in your workplace. It certainly keeps me on my toes as an employment lawyer. Today, we're going to talk about discrimination, a little bit about hiring, interviews, about criminal history when we're hiring, drug testing, and then we're going to talk about lots of employment issues in between, and then we're going to discuss firing, retaliation, disability, including drug testing at that level, and then conclusion. It has been years since the courts have developed what is a protected class, when someone can be discriminated against. Discrimination has been around for a very long time, probably longer than any one of us that it's on this webinar. However, as the courts come after year, they are trying to curtail the discrimination that takes place in our workplace. And what does that mean? Well, it means that discrimination and discriminating against someone can apply to hiring, firing, taking any adverse employment action, demotion, lack of promotion, pay reduction. In fact, it doesn't even have to be a pay reduction. It could just be a reduction in the title itself, go from supervisor to non-supervisor. The federal courts and the federal law is what everyone knows as Title VII of the Civil Rights Act, and that prohibits discrimination based on an employee's race, color, religion, gender, or national origin. And it's recently has been interpreted by the US Supreme Court to encompass claims based on sexual orientation or gender identity. Federal courts also have the American with Disabilities Act. When you get down to the state level, many states are more expansive in their protection. New Jersey, for example, prohibits discrimination based upon race, color, religion and creed, national origin, ancestry, disability, perceived disability, sexual orientation, marital civil unit status, age. Anyone know what the age in federal courts? 40, pregnancy, military service. And in fact, now I can tell you that in New Jersey, the legislature are considering bills that both obesity that does not have to be connected to a medical issue, as well as someone's height, is also soon to be considered a protected class. So what does that mean? I mean, don't discriminate on the basis of protected characteristic. If you go through all those protected characteristics, again, not to be cute, but the only people that are not in a protected class are white heterosexuals, males under the age of 40. That alone, without looking at anything else, may in fact be the only non-protected class. Of course, if you have national origin and military in there, when they have other descriptions, certainly they too can be discriminated against. So what does an employer do to make sure that they can protect themselves from the lawsuits, from the complaints, from the receiving one of those letters? Employers must make sure a couple things. First, you always have to have a clear, well-defined reason for firing someone or choosing not to hire them, and make sure that it has nothing to do with their protected characteristics. While we may live in some at-will states, meaning that an employee can be hired or fired for any reason whatsoever, demoted for any reason whatsoever, because the protected class are so expansive, that at-will doctrine is chipped away. When 25 years ago, longer than that, the at-will doctrine, people would say, just fire them, don't give them a reason. And now, good counsel will tell you, document, document, document. It is very important that the employer make sure that they document everything. And the hard part is that most companies are not in the industry to produce paper. Now, we represent many education and institutions, and as much as there's paper and there's books found throughout the school, they don't necessarily write people up. They don't necessarily have performance reviews. They don't necessarily document the meetings. And I encourage every employer to think about the policy of how we document the responses, how we document the meetings that we have with our employees. They don't need to be a letter, a 4-page letter. It can be as simple as an email saying to the employee, as we discussed today in our meeting, blah, 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 blah. That's all it has to be, because without any documents, it didn't happen. So it is important that employers understand that they must document their business reasons for the decisions that they make. First, you got to start off with a handbook. Everyone listening to this webinar should have a handbook. Handbooks come in all shapes and sizes. They don't need to be hundreds of pages long. They need to identify the core policies that must be in a workplace. And one of the core policies is a zero tolerance for harassment and discrimination. And there must be a complaint procedure that's written in there that is easy to read, that is unambiguous, that is disseminated to the workplace. So everyone knows that if they feels that they are being discriminated or harassed, that they have a channel that they can go to. I'm also going to advise everyone that it shouldn't just be one person that they report to. If there's a reporting, it can be two people. I'm also going to advise everyone that it shouldn't always be in writing. If someone comes and verbally reports something, you still have to take action. So it is very important that things get written down in a timely manner so that if someone does believe that they've been discriminated or harassed, there is then a response to it. There is something in writing to show that it did or didn't happen. Although places of business have zero tolerance for harassment or discrimination, sometimes people act in a way that is not in accordance with their culture. And then the question becomes what to do. If someone says something that is harassing in nature, but is not egregious enough for the termination of that person, you are not forced to terminate that person. You're forced to take corrective action, but you're not forced to terminate that person. And it is a business decision of how to handle that harassing or that discriminatory behavior. There are some exceptions, obviously, to the role of discrimination. BFOQs, bona fide occupational qualifications. Here you can hire someone based on religion or sex or national origin, where in those circumstances, that qualification is necessary to the normal operation of that business or enterprise. Religion, the US Supreme Court has held that religious institutions have the right to choose their own ministers, largely accepting those positions from discrimination laws. In other words, they can choose who they want to hire, even though that hiring might be against an anti-discrimination law. Title VII of the Civil Rights Act also exempts religious education institutions from prohibition against discrimination on the basis of religion. And again, state laws all may differ on these points. So it is important that you understand the state that your company is in. If there's multiple offices and multi-states may apply to each of those offices differently. And that's why it's very important to understand the harassment and the discrimination laws found within the state and get to know your legal counsel. As I say, before any of my clients make a decision, I'd rather them pick up the phone and ask me the question before they do something that would get them in further trouble. Although being in trial may be fun to some, it's not a fun experience. I'm a risk adverse person. Trials are long, they are lengthy, they're emotionally draining, they're financially draining. And what one doesn't realize is that if the plaintiff prevails, there's what in employment law, there's what is called fee shifting. And the fee shifting means that when a plaintiff prevails, the defendants will then have to pay plaintiff's fees, the attorney fees. They are awarded the attorney fees separate and apart from a jury. A judge gets to do that. So if in fact plaintiff is found to be in the right and the jury awards plaintiff, for example, $10,000, at the end of the day, if the lawyer charged $400,000, that lawyer might see that $400,000. So it is of the utmost importance, especially in employment cases, that you try to curtail any risks that you may have and that you attempt not to have a complaint filed and that you make sure that you can avoid the risk of an employment litigation. How about the interview? So when you're hiring someone, can we just ask any questions? Can we ask, how old are you? No, that's an obvious question. No, because if you ask that, then if you make your decision based on someone's age, then perhaps you could be found to have violated the laws against discrimination when it comes to age. Do you have a girlfriend? Again, these are protected classes. And if we ask these questions that are personal in nature and you make your decision based upon the answer, then you may be held responsible for violating the laws. Again, are you comfortable with being the only woman in the office? You guys are pretty good with numbers, huh? Where are you from originally? These are questions that you need to avoid. When it may be hard to prove that you didn't hire that person because of their answer, you don't want to be in the situation that that is the claim. Refrain from asking any questions about a prospective employee's protected characteristics. If you take into account personal experience, such as perceived hygiene, grooming, take care to do so that it won't and it can't be interpreted as discriminatory. Try to pronounce every applicant's name as accurately as possible. If you don't know, ask them how to pronounce their name. Attempt to refrain from asking them more than once. Make an effort to reach a wide array of potential applicants. It is completely acceptable to have strict standards and expectations, but it is advisable to think outside the box concerning where applicants are coming from. Does every applicant know someone who works in the office? Have you posted your job opening online? Think about these things. Do you have expectations about what kind of colleges your applicants attended? Again, some of these questions may not be your intent to be discriminatory, but if they are perceived to be discriminatory, at the end of the day, there's an impact on that person, and they may feel that you didn't hire them because of their responses. Criminal history. Obviously, it depends on what industries you are in. That criminal history may or may not come into play. Some states prohibit employers from asking about a job applicant's criminal history on the application or the initial interview. And if you believe that you need to know an applicant's criminal history before deciding, make sure that you check the state before accepting applicants, because if your state prohibits about asking the criminal history, you can still decide to run a background check after the initial interview. It is most important that your job application, while I recognize many of them are online, when that person comes in for an interview, or if you're doing it remotely prior to the interview, you can still ask some questions on a paper, and there should be a box and a signature line that says, I attest that all my information is true and accurate, and I understand that if I'm not telling the truth, or if I find that something is not truthful in my application, that I may be subject to discipline, including termination. I'll tell you a story. A couple of years ago, an employee lied on their job application and said that they had a license that was required for the job. He was applying for an engineer job, and he lied on his application, and he said that he had a certain type of license that was required. Well, we came to learn that he didn't have that license, and in fact, we then ultimately terminated him. And it was important that that box checking off that I attest to tell the truth, and I understand that if I don't tell the truth on this piece of paper, that I could be subject to termination, was in there, because it showed that we didn't terminate him for any other reason but for lying on the job application. And although he did try to claim that the real reason for the termination was because of the way that he looked, it had nothing to do with the way he looked. It was because he was not truthful on the initial application that came through the door. Drug testing. This is obviously a hot topic right now. Employers must provide a safe work environment, and drug testing is one option to keep the employees, the equipment, and the property safe, and their coworkers safe. And each company must consider their own business needs, in addition to the federal and state laws that are out there. Again, being transparent with what the drug testing is in your business is of the utmost importance before the applicant walks through the door, because you might have random drug testing, you might have pre-employment drug testing, you might have suspicion drug testing. So knowing what these policies are, let's go back to the handbook for a second. That is an important policy to have in the handbook, so it is spelled out so everyone knows what the expectations are. You may be required to have a policy in place because you're a federal contractor or hire drivers that comply with the DOT, Department of Transportation regulations. You may have experienced work-related accident claims, but didn't previously have a drug testing policy in place. Again, if you are testing after a work-related accident, there's a way to test. It's not, the employer doesn't test, obviously. There are their own industries out there, companies out there that provide confidential testing. So it is important that when one is implementing a policy, again, it's all about risk management. Know what it is, employ a company, a third party to do the testing, and make sure and advise the employees what kind of drug testing policies you are going to have in your place of business. And when they sign off on the receipt and acknowledge the handbook, they sign off on these drug testing policies. Handbook's not a contract. You will have that disclaimer in there, but at the end of the day, they recognize that they too may be subject to certain drug testing policies. This reduces the risk of litigation and protects the employees. Consider, all the factors, what the policy will have on the business. There's many companies out there that don't want to have random testing. They only want to have suspicion testing. If you're going to require the testing and it's pre-employment screening, how will that impact the candidate's experience? And again, multi-state employers must know and understand what each state has and what's required and what's lawful and what's not lawful. When we drug test, there's many laws that are implicated. The American with Disabilities Act, that's an ADA, the Equal Employment Opportunity Commission, that is the agency that addresses and adjudicates employer and employee disputes on the federal level. Department of Transportation, Occupational Safety and Health Administration, Department of Health and Human Services, mental health parity, HIPAA, as well as union and industry regulations. I don't know how many of you are out there have union shops, but of course, drug testing is permissible. The impact is negotiable, but drug testing is permissible. So while not going astray from the collective bargaining agreement, knowing what you can and cannot do is obviously important to ensure a drug-free environment. The courts have generally ruled that the pre-employment drug testing does not constitute a medical exam under the ADA. And the EOC has said that such screening should be administered only after a conditional offer of employment has been made, because it's at that point the employer may need to ask applicants some follow-up medical questions. So again, having everything documented and in writing, knowing the onboard process for your employees is very important. Everyone should have a checklist, and the checklist is complied with. And so you go in a specific order of when you're interviewing the employees and when you make an offer to the employees. What happens when now we've hired an employee and at the end of the day, they're just not a good fit for the company. They're not doing their job. They're not making the widgets fast enough, or they come in late all the time, or they take an extended lunch. And while this may or may not have impact their performance, it's irking a lot of their coworkers. What do you do with that? Look, there's hiring, firing, and a whole bunch in between. And so it is important that the supervisors are trained to understand what to look for with their employees. So for example, if the company has performance reviews, the performance reviews should be standardized. The supervisors should be taught how to fill in and respond to performance reviews. Employees should be able to respond to their performance reviews. Are they every 6 months or are they once a year? When do they take place? And don't miss them, because if you're going to have a performance review, it is better to have a performance review that is an honest performance review than not to have any at all. How about training supervisors when, if someone, for example, has a medical issue and they have to take an extended lunch, does the employer at that point have an obligation to sit down with the employee to find out if it's just they're taking an extended lunch because they feel like it, or they're taking an extended lunch because they have a medical issue? It is important to have conversations with your supervisor that when they see something or they observe something of their employees, that they take it back to the HR managers and together they come up with a plan. Because just firing someone because of a reason and it's not well documented could get the employer in hot fire. Is there progressive discipline in your handbook? Okay, what's progressive discipline? It says that I have to first give a verbal, and then I have to give a written warning, and then there's a suspension, and then ultimately termination. Except if it's in a collective bargaining agreement, I'm not a big fan of progressive discipline because I think that all disciplines should be treated different and all the severity of the actions of the employees should be treated different. But I do believe that everything should be documented. So when an employee does something that is adverse to the employer's policy, it needs to be written down. And maybe it can't wait another 3 months to the performance review. Maybe there needs to be an email to the employee reminding them of their conduct, reminding them of their duty. What happens when an employee says to a supervisor in an email, I can't work the next week because of my medical condition? Your supervisors, the bells should go off in their heads that they should come and talk to HR immediately so you then can decide what to do with that supervisor. The with the employee, the supervisor may say, well, I didn't come to you because that employee always claims that she's sick. Again, training our supervisors what to be on the lookout for and reporting back to HR is extremely important because it will then make sure that the employer, when they are ready to sever ties with the employee, does so in a lawful manner that doesn't get them in hot water and doesn't create a lawsuit. Obviously, it's against federal law, it's against many laws, state laws, to retaliate against an employee, including firing that employee for engaging in protective activities, filing a complaint. How about commencing an investigation? How about reporting a complaint to HR, not necessarily just the filing the lawsuit? Telling a supervisor about harassment or discrimination, complying with an investigation about harassment, refusing to take part in illegal activity, resisting sexual advances, sexual harassment, quid pro quo, hostile work environment, requesting accommodations, whether it's disability or religious practice, or asking a coworker about salary information. Take a moment, talk about requesting an accommodation. If an employee requests an accommodation, every HR professional should know that if at the end of the day, they still cannot accommodate that individual, they still must have that interactive process. So if you get to the end result that you can't accommodate that individual because it is a change in the essential functions of the job, and you don't have that interactive process and you terminate that employee, even if at the end of the day, you may have been right that it would have changed the essential function of the job, or you had to put a $50,000 elevator in the building that couldn't happen. If you didn't have that interactive process, the employer can still be held responsible for a violation of the laws because you failed to have that interactive meeting, that interactive process. So it's super important that every HR professional communicates with legal counsel, talk about when they're about to do something to an employee, when they're about to take an adverse action, to make sure that it is done right. And the HR's responsibility is to make sure that the supervisors understand what it means to be a supervisor. Because if we fire someone for retaliation or fire someone because they made a complaint, it can be held responsible. If an employee engages in a protected activity and the employer wants to fire the employee for a different reason, here we go. Make sure that the employee's complaint questions are handled fairly and in accordance with the policies and the laws. And then you terminate the employee, making it clear that the reason for doing so is completely unrelated to the employee's protected activity. Probably most of you, I'm going to say 80% of you, that say when they're about to fire someone or they are disciplining someone, I am sure the employee at that point brings up, well, I feel that I'm being harassed or I feel that I'm being bullied. What do you do with that? You still have to take their complaint seriously. And then at least there will be less of an exposure if there is a lawsuit. an employer is underperforming or has repeated absences and claims a disability, employers have certain steps that they can take. The interactive meeting we discussed. Employees may be entitled to take medical leave under the Family Medical Leave Act if you have the requisite number of employees and if they meet the threshold for the hours worked. States also have their own medical leave. An employee cannot be fired for using medical leave. They can be fired for the poor performance or poor attendance if their disability has been accommodated. I'm sure my fellow colleagues out there get more questions that, well, I want to fire them, but now they're on FMLA. What do I do? And I want to fire them, but they're on workers' comp. What should I do? Now, that's a fact-sensitive question. I'm not going to answer it, but how I am going to answer it is the following. You can't fire them for taking that protected activity. But if there are other documents and information that show that that employee is not meeting the standards of the employer, then absolutely you can terminate them. So best to set the clear policies in advance about what accommodations we made for certain disabilities. And, all disabilities are not physical. There's some mental health disorders that are disabilities, and they are treated the same as perhaps maybe the broken legs are. So again, in the handbook should spell out certain accommodations that may or may not be given and spell out their policy on disability and leave acts. But drug testing. So we now have a good drug testing policy in place. What do we do about it? Now, let's say we have a reasonable suspicion policy. Train the trainers, train the supervisors, make sure that management personnel are more likely to identify an issue sooner and provide the support to employees. Some of the observations: strong odors, questionable movements, dilated or watery eyes, flush, confused or blank facial expressions, slurred speech, argumentative, irritable, or drowsy behavior, or sleeping, falling unconscious, or otherwise being unresponsive. Sleeping is usually the one that you see. Someone is sleeping on the job. At that point, they then make a claim that they have a disability. And again, it's a process to go through. So do they have a disability that they notified the employer about? Did the employer know about the disability? Is sleeping a result of the disability, or are they just sleeping on their job, not being a good employee, or do they fail the drug test? And again, it's a process that goes through. No one said that you can't put someone on administrative leave if in fact you're investigating the claims. You have every right to do that as well, obviously depending on what some of the policies say, if you have a policy. But that person, if at the end of the day, if you're investigating claims and you put them out on leave and you still make them whole by paying them, there is much less exposure than if you just fire them without understanding and doing your due diligence. Because if you fire them and you fire them wrongfully, a lot more will be at stake rather than just their paycheck. Marijuana, cannabis right now, it's legal in many states. And we've done seminars just on cannabis and what the effects are in the workplace. You are always allowed to test an employee for drugs after a workplace accident. But what happens if, in fact, there was no workplace accident, but at the end of the day, you feel that someone is coming either high or drunk to work? So again, having the drug testing policy in place is extremely important so that there are rules and that the employee knows that they need to follow. And if they are terminated for illegal or even legal drugs in the workplace, there is a reason for them being fired. I can't express the importance of documenting everything, the importance of ensuring that the handbook is disseminated to all the employees. If policies are changed in the middle of the year, to disseminate those policies, the policies that are changed that have a significant change annually, they are highlighted to the employees. So the employees know that in this 100-page handbook, that, for example, the FMLA policy has changed. Upon dissemination of the handbook, training your employees, not just the supervisors, but training the employees, reminding them that, the law against discrimination is not a code of civility. Because someone's not nice to you does not necessarily mean that it rises to the level of harassment or discrimination. And here's what it does mean if someone is harassed and discriminated against. And it's important for the employer to have a culture to say that we have zero tolerance, and that in fact, we take every complaint serious. When a complaint is lodged, it's important to document that complaint, to have an investigation, whether the HR person is doing the investigation or a third party comes in and does the investigation, someone that is impartial, that's effective. At the end of the day, you don't have to find that someone harassed. You don't have to find discrimination. If it happens, it happens, and it needs to be stopped, curtailed, and that person may or may not get terminated. But just because someone complains does not necessarily mean that it happened. But after the investigation takes place, I always urge that you need to close the circle, as I say. Letters need to be sent out to the person that complained, as well as the accused, not necessarily telling them what personnel actions are taken, but at the end of the day, so that there's a document that says we conducted an investigation and here's what we found. And the company has zero tolerance for any harassment or discrimination and retaliation. Because sometimes that person is the one that's going to end up getting fired. And they say, well, the only reason that I'm getting fired is because of the complaint that I made. So long as the employer documents everything well, I am not going to tell you that lawsuits don't get filed. Lawsuits are going to get fired. If I sat here and said to you that will curtail lawsuits getting filed, I wouldn't be telling you the truth. However, I do feel that it gives your legal counsel the best defense that you have by making sure that everything is well documented, no matter if it takes a lot of time to document it, and that you will believe that this is now most of what you do is taking employees' complaints. Employees right now are, I think we came out of COVID and they're aggravated. They feel that they're stressed, their mental stress level is higher than ever. They're aggravated, they're agitated, and they're not treating each other with kindness. Again, treating someone with kindness, making sure that people are treated with respect is important so that you don't give rise to the level of harassment or discrimination claims. So as HR professionals, it is important that the hiring and the firing procedures are in place and they are followed. That's the easy part. The hard part is everything in between. And what do you do when an employee makes a complaint and doesn't look in the mirror and recognize that this is not a good place for them to work because they're just not doing their job to the level of the employer's expectations? Those are where you need to, I think, make sure that everyone is well trained and equipped to handle those employees' issues as well. So that's all I have of, I could speak for hours, but I know that it's a abridged version. I thank everyone for coming during lunch hour to listen to me, but there's lots and lots to talk about. But let me just take a few questions that I see in the chat room that I can answer. And if anyone has any other questions that they want to ask, feel free, if I didn't address it or if I addressed something and you want some further clarification, to shoot me an email. Certainly would like to answer them. Here's one question, and we touched upon it, but let me elaborate a bit more. As I am having a discipline meeting with an employee, the employee claims that she is being harassed by her supervisor, the same supervisor that disciplined her. Now what do I do? The discipline stands, certainly, at the end of the day, it is your responsibility to make sure that the supervisor is not retaliating against the employee. But by the time you're disciplining that employee, I'm sure you've looked at all the records and realized that that employee needed to be disciplined for one reason or the other. But now that the employee has mentioned the word harassed, you need to conduct an investigation. You need to conduct a workplace investigation just like you would any other time if she wasn't being disciplined. While I recognize that you might say, well, clearly it's just the defense of being disciplined. It may well be, but you need to do the employer a favor to, again, to limit the exposure and make sure that the investigation takes place. And at the end of the day, the investigation takes place and there was no harassment. You then can close the circle, as I say, and write her a letter and say, in our meeting in which you advise that your supervisor was harassing you, upon an investigation, we found that there was no harassment or no discrimination. So even though your gut might tell you that she's just using that as an excuse, you still have to investigate. So in the era of COVID and vaccinations and unvaccination, if someone has a note from the doctor that they don't want to be vaccinated, yet that's the policy of the company, what do I need to do? So vaccinations are a request for a reasonable accommodation. So if it's a requirement of the company, you would have to treat the request not to be vaccinated, just like you would of any medical issues. You would need to sit down with the person, have that interactive process. And at the end of the day, the company needs to decide if in fact the employee can be reasonably accommodated and for not being vaccinated. That's a decision for the employer. Again, there are the reasonable accommodations do not necessarily mean that that person gets to work from home or remotely. There's a whole host of other accommodations that can be made. And so after that meeting, the decision to or not to reasonably accommodate that person must be made, and that person is provided a response. Do I have to handle a verbal complaint the same as a written complaint? What happens if the person says, I don't want you to take this any further? So that's, I'm sure we all get that. I don't want this to go any further. Please keep this confidential. You as HR people, as a representative of the employer, must investigate, even if someone says that they don't want to investigate. Now that they told you, you have knowledge, you're equipped with that knowledge, and whether it is written or whether it is verbal, must conduct an investigation pursuant to your policy, and your policy should say that as well. The investigation and the complaint, certainly it's good best practice to try to keep that confidential, but you can't not do anything about that complaint. A bad defense is saying, well, she told me or he told me that he didn't want me to do anything about it, and so I didn't. That's not gonna help me if I have to defend in a lawsuit. Let's see. The word bullying, is that the same thing as harassment? The answer is yes. In this day and age, if someone feels that they're being bullied by someone, whether it's a coworker or supervisor, I would suggest that the same type of investigation takes place, because at the end of the day, I understand that words just might be thrown around, but you can then understand the culture of what's going on in the workplace, and curtail if there's even just mean people, and saying that this is not the place that people can be mean to other people, because no one wants to work in that sort of an environment. So if the employer doesn't document anything when terminating an employee, what type of advantage does that leave for the employee? It gives the employee a huge advantage. So again, emphasize document the reasons for terminating. The letter that's going to the employee should also, can be detailed, but it leaves the the employer is exposed if you don't give them reasons for terminating their employment. How can I get directors to stop discussing employees' mental health self-care without being mean or insensitive? You need to have that discussion with them. Need to remind the supervisors that they are discussing people's mental health status, and that they could be held responsible, because obviously, if you're conducting yourself within the scope of your employment, there's some less liability that can be had. There's individual liability. I don't want to scare people, but I scare people this way, saying that there could be some individual liability if you continue to discuss someone's mental health or self-care, because it's a violation of some of the laws and the regulations out there. If there's an employee on FMLA for numerous mental health diagnoses and claiming is due to lack of accommodations, her performance is subpar, we want to term her for those reasons. How do I term her? And I'm sure she says, and I have a lawyer. So, again, I think that's a fact sensitive question. I would love to know if her performance was ever documented being subpar. Did you sit down with her to talk about any accommodations? So that's a whole host of questions out there that I would love to answer. Look, I love to be able to create the narrative for my clients. Again, I can't guarantee that you're not going to get sued, but I think I do a really good job of attempting to diffuse and to defend lawsuits, because we do it properly. There's a way to do it, and there's a way you're going to get the same end result, but I can guarantee you that there's going to be more exposure. And at the end of the day, while I am sure employees are terminated for lawful reasons, there are out there that are terminated for unlawful reasons, and these laws were put in place to protect those people. And while I accept that, I do recognize that there is no more at-will doctrine. And so we just have to make sure that we handle all the employees' issues with a sensitivity and empathy, and making sure that we protect the employer by doing things right, that again minimizes the risk. So that's all I have for now, and my time is up. I thank everyone, and again, if anyone has any questions concerning employment within the workplace, feel free to shoot me an email, and I'll get back to you, and hopefully I can assist.
Thanks, Stephanie.
You're
welcome.
welcome.
Valuable information on hiring and firing challenges. The NPHR team is here to help guide your organization on any HR compliance issues. If you'd like to learn more about how we can assist your organization, please visit our website to set up a short 15-minute call. Be sure to join us next week for our webinar, Recruiting in 2022. Visit our website to register and to see the full calendar of upcoming events and available resources. We will be sending out a recording of today's webinar along with the presentation slides this afternoon. Thanks for joining us, and have a terrific day.